All right. After being bashed that we don't have ladies on the panel, at last we have them. Thank you. Yes. We'll move straight to the session. It is said that the rule of law is the foundation of a civilized society. So our topic today is about legal issues affecting African registries and registrars and also resellers. We are going to focus on alternative dispute resolution mechanisms for CCLDs, registrars and resellers. And we are also going to look at a wider perspective that the changing legal and regulatory landscape for doing business. Today, we have a very heavy panel here. In fact, I'm humbled to regulate such a panel. On my right, extreme right, we have Sarah. Sarah is the legal counsel for tzNIC. She has many years experience, more than 5 experience in the industry. She is responsible for the intellectual property rights there. And she's the one who ensures compliance on regulatory issues within the TLD. Next to her is Lucky Masilela. If you don't know Lucky, I think you're in the wrong room. Lucky Masilela is the CEO of Africa, I don't know what, because we were all actually pushing Mark to answer questions, but actually Lucky, we should have done it. Then there's one unique thing I should tell our Tanzanian colleagues. He lived here for so many years. So don't speak Swahili in front of him, he knows it. He pretends not to hear, then answers you after you've embarrassed yourself. So he's your son, he has come back home. Welcome home, Lucky. On my immediate left is Madeline. Madeline is the CEO of Resolution Experts and also the founder of that organization. She's also an advocate, a specialist in commercial arbitration, and she also assists in the dispute resolution for .tz. On my extreme left, I don't know this guy, but I'm told he's a professor, I'm told he's a doctor. When I was trying to Google his bio, my computer crashed because it was 1,000-page bio. But he got his PhD in 1977, when we didn't know what PhD is. Yeah, seriously, he has a PhD, a real one. And he's done so much. He's one of the founding fathers for Afrinic, one of the first board members, the initial board members for ICANN. I can go on and on. Just get on your Google and get his 1,000-page bio. So it's quite a tough panel. So I will start by asking Sarah to lead us on, maybe just tell us a brief on what an alternative dispute resolution mechanism to make the conversation rolling. Thank you.
Good afternoon, everyone. I'm delighted to be and humbled to be speaking before a whole group of techies. I'm usually excited when I go to speak with lawyers. It's easier. They think you're the techie. But now I have to be careful because we're lucky it's on alternative dispute resolution. If it is DNS, then I'll be very, very, very humbled because I'd get questions that I wouldn't answer. But to go to the question asked by the moderator on what alternative dispute resolution mechanism is for domain name systems, first of all, I'll start by giving us a brief background that ICANN, the aspirations of having alternative dispute resolution for domain names dispute actually comes by the policy which was passed by ICANN board back in 1999 on uniform domain name dispute resolution policy. And this policy was adopted voluntarily by CCTLDs and GTLDs. It's voluntary adoption, so not every CCTLD has adopted it, but Tanzania has adopted it. And the aim was actually to solve the disputes that emanate from use of domain names. As we understand, the sort of disputes that come up with domain names, they are intellectual property rights, mostly trademarks, and sometimes patent rights. And at the back of this decision and policies, they thought that these kind of disputes, if they go to court, we all know the stories that go with court cases. It can take years. And while such things are going on, people's trademarks, service marks are at issue, and the thinking was we did not have to, we wanted to have the domain name use friendly for people, particularly with businesses. They can protect their rights, and they can have, where there's a dispute on whether this name belongs to A or B, the dispute is resolved so quickly such that people can continue transacting their businesses online. Hence came the alternative dispute resolution mechanisms. Traditionally, that would stretch to arbitration. Arbitration is also similar to litigation, but you have an umpire, that is an interested party, who sits and listens to this part A and part B and decides the winner. He writes a judgment. It's not a judgment. Madeline will quote it right. And then, of course, that is binding upon the parties. And you can only go back to court for very, very limited issues, which I believe Madeline might be able to point out in detail. But for uniform domain name dispute resolution policy, it's not even arbitration. It's called administrative procedure. They wanted to get away with the technicalities that went with arbitration and litigation. In this case, you will have an administrative panel of people. It can be one person or it can be two people. They do not have to be lawyers. They are people who have technical background. They understand matters of domain names. They understand issues of intellectual property and trademarks. And they will sit down and determine the domain name disputes by looking at three particular issues according to the policy. This is whether the domain that is registered, that is being contested for, is confusingly similar, or it resembles a certain trademark. Second criteria would be whether this person who has registered this domain in dispute has no legitimate interest in the domain. And finally, whether it was registered in bad faith. And there are two ways that bad faith is looked at with this policy. It can be on registration alone, or registration and use, that you're doing that you have bad faith in those two angles, the way that you registered it and how you are using it. Of course, how these are determined, it's a lot of jurisprudence that has been developed over the years, of course championed by the famous arbitration, mediation and arbitration centers, or alternative dispute resolution centers. One is based in America. Europe, I believe, has the WAPO, Arbitration and Mediation Center. Asia has theirs, and of course, Africa has none. But I understand that ZACR has their localized sort of domain name dispute resolution that is not tied to the UDRP. Position of Tanzania, we have the varied dispute resolution system for domain names that has adopted the UDRP model as issued by ICANN. I hope that was not.
Sarah, that was good contribution. We'll ask questions at the end when all the panelists have made their contribution. And now, Lucky, you are a highly experienced CEO. You are also a very highly experienced business person, leading in domains in Africa. From morning up to now, people are just saying 1 million like South Africa, 1 million like South Africa. Now, share with us, how has the alternative dispute resolution assisted your work at the registry?
Thank you, Chair. I think what I would want to do and cite here is the importance of alternative dispute resolution and the mechanisms that are in place which attempt to address issues before they reach to a dispute point. Now, these mechanisms are now put in place whereby when a name is to be made available to the public, there are then provisions that ensure that only certain individuals have rights to that name. If we were to cite a practical example, when we were launching .Africa, we had to launch .Africa in multiple phases. And these phases, by their design, they were meant to protect entities that own certain names. The first phase, which we call Sunrise, the Sunrise, it only allows for trademark holders. Only people who are trademark holders can apply for those names. And those names, again, must be in the trademark clearinghouse. So those marks will be in the trademark clearinghouse, validated. So if you had to apply for a name, you would be allocated a token. And at the end of the evaluation period, it is only then your application is accepted. Then you can acquire that name. Parallel to the trademark clearinghouse, we also have that mark validation system. Also equally, that was to manage trademarks that were registered in Africa. And it was also a system that we introduced ourselves to address trademark holders that are in Africa, that made it affordable to lay a claim on your particular name. So we came up with the MVS, which we call the mark validation system. However, in the terms in regards to the hierarchy of TMCH and MVS, TMCH took a higher hierarchy and MVS took the next level. But when a trademark would be in Africa, then the trademark against the MVS will take a privilege or precedence, or be recognized first. So these mechanisms, in their very nature, they make sure that we do not get to a dispute resolution point. You know? Then you have the next stage of after Sunrise, whereby you have premium names, which is called land rush premium names, or brand names that are applied for. It protects, there's minimum guarantee on those names. Then finally, you have general availability. Now, another practical case is, whilst we are releasing names under .Africa, we have introduced in our policy what we call a government reserve name list. Now, the government name reserve list allows for governments across Africa, the 54 countries, to apply for their names that are considered of importance politically, historically, or the heritage, and there should be at least 100 names that will be ring-fenced. And then also, plus on top of the 100 names, you have 20 names which are considered offensive, that would incite violence in the country, be it of a religious nature, cultural nature, or anything, but names that will be equally ring-fenced or put in a lock never to be used. This is another mechanism to ensure that we do not reach a point of dispute. So governments will then, it's a proactive manner of protecting those names. And this is what we call the government reserve name list. And for me, these mechanisms, Chair, have ensured that we limit issues of dispute resolution or having to go into arbitration. However, once you are in it, we are excited that there are mechanisms that equally deal and mitigate against instances once you are into a dispute resolution. We, immediately after .Africa was allocated to us in 2014, in the same year in July, we signed in 2014 in March. In the same year in July, we had to stop the whole pre-contractual exercises because it had to go through an independent review process. There was an applicant that was challenging the allocation of .Africa to us, so it required another legal process, independent review. It was a panel which is governed by this International Dispute Resolution Association, and that panel had to conclude on its finding, and its findings, of course, they ended up in the courts in the USA. But I'm citing more of your practical cases which tend to mitigate or manage issues of having to go through a dispute resolution. Finally, we, part of this government reserve name list, are working with the African Union Commission against the very understanding that we need to have a mechanism whereby where governments across the continent around those 100 names, if there is going to be a conflict on names or names that are being claimed, that committee will then be the one that does the negotiation around names without having to go to WIPO or any of these international dispute resolution bodies. So this will be done within Africa Union Commission. That body itself is under, it's still being formed and all the terms of reference being developed. This is to address issues of who owns a name like Nile.Africa, or who owns a name like Sahara.Africa, or who owns Mwenge.Africa, you know, and many other names that are dear to countries and names that tend to cut across our political borders or boundaries. And they need some kind of regulation or some understanding or some resolution, a body, an independent body, to come up with a final pronouncement on who would be the rightful owner of that name. Those are some of the examples. Thank you, Chair.
Thank you, Lucky. You have brought a very different perspective to it. We always look at dispute resolution to prevent people going to court. You have put in measures where you don't even have to reach the dispute resolution, another backup on backup. But any system has a challenge. And Madeline, you being a CEO and also an advocate, can you tell us what's the challenge of the alternative dispute resolution?
Thank you, Mr. Chair, or moderator, may I say, moderator for today. The challenge that we are seeing for my case, maybe here in Tanzania, is who solves these disputes, domain disputes. Who solves them? The challenge that we're facing is that we see that, let me go back to what I learned here today, is that we want to increase the number of domain registrations. With that increase comes a lot more challenges, and those challenges include more disputes arising amongst registrars, registrants and the players within that domain space. Now, what we see is that these disputes in our current situation are not really being resolved to their entirety. Why do I say that? We find that persons would will not use the particular system that is in place, which is the dispute resolution system that my fellow Sarah has spoken about, and instead they would sit in a manly, sort of friendly way and an amicable way and settle it mano a mano out of that particular system. And so you find that a complainant would meet up with the particular person who has who has registered the domain, and they would probably pay them an unreasonable amount of money for them to win over that particular domain. Now, this is going away from what has been set by the UDRP policy and rules and the supplementary rules that we have in Tanzania for us, in the sense that there is a local provider providing for dispute resolution, which is a firm that I run, whereby we've been approved by the tzNIC to administrate these kind of cases. So you find that we haven't been able to assist or administrate any cases within that time span since we got that approval or that approved sort of accreditation from the tzNIC. Now, why are people not using the platform or the system that is in place? One is the issue of know-how, knowledge, or awareness of it being in place, one. Secondly is the capacity issues that we're facing. I think it's an African sort of problem in the sense that of understanding the policies, the procedures, and the rules applicable to the domain name dispute resolution system. In the legal field, I would say we lack that know-how. We need that capability to be enhanced. We need to be exposed. We don't have any precedents that we can rely on. We have a lot of precedents with respect to international and in a global level, a lot of precedents that we can go back to and learn from. But from an African perspective, it's very difficult to find these precedences. There's no sort of harmonization in that manner. I guess another challenge maybe I could speak about would be we could go back to my notes. The importance of also embracing the online dispute resolution. This is another thing that, of course, it might not be a very conducive platform right now or system right now because of the acceptance aspect of things. But online dispute resolution would cut down the cost even more. Why we have a local provider for these is to cut down the cost, because initially you would have to take your complaints to the WIPO or to an international organization that is approved to resolve your disputes. Now we have a local provider, yet persons are still not using the local provider, complaining that the costs are too high, and so opting for an amicable settlement out of that particular system, being it informal sort of settlement, which is not really acceptable. So in order to reduce, maybe, there could be a platform that is an online-based platform that assists these complainants to be able to file their complaint in an online environment, being it that domains are online products. And being that domains don't have any sort of jurisdictional boundaries, that works even better. To have that sort of efficiency provided for complainants to be able to route their complaints in an online environment. Now, I think the issue of capacity, the issue of having alternative means of filing a complaint, all these, I think, if worked on, would be able to create a more vibrant sort of playing field for domain dispute resolution, and advance that sort of that field much more. Yeah.
Thank you. It was intentional to leave Professor to speak the last, and that's why when I started with a quote so that I look learned. I said the rule of law is the foundation of a civilized society. Now, Professor, we have left the big question to you, and you have listened to us here. And tapping from your experience of many years, and you have traveled in many countries and witnessed a lot of challenges. So, what are the changing legal and regulatory landscape for doing business?
This is too complex for the old man. But let me answer you this way. I think CCTLD operators should get close to lawyers, and because the changes that are occurring can also be contextual. It can also be from the environment. And I'll use a different CC to illustrate what I have in mind. In my case, the GH has gone through some legal issues, and mainly because you are pushing several regulatory areas without realizing. You are pushing the telecom frontier. Sometimes you are pushing pure ICT, okay? You are pushing finance-related things. You are even doing consumer-related problems because you have tons of consumers. You have to deal with intellectual property, and you have to deal with law enforcement as well. Just to name a few for you to get the context. In the case of GH, as an example, we've been operating from perhaps 95, 96, quite stable registry. But in the last month of an outgoing regime, government, a law was passed, an act of parliament that made it criminal for the CC to continue to be operated by the delegated organization. That's the context, meaning it has nothing to do with the service. People were upset, but still a law was passed. Okay, so you have to meander that. Naturally, what we did was proceed to offer to hand it over, and I got help from our famous Alain as an example. But system is well upgraded, functioning well, government has its operation, but there's no host, okay? Meaning there's no real host to do the job that the original CC delegate was doing. So you still have to manage that, and potentially could be a legal challenge, but we are managing it. Another issue that we face quite a lot is dispute-related issues, but they go to court. Okay. And they all have to do with speculators, and the speculators foresee that Google will become important, so 8 years earlier, they come and try to register the name, and the old man at least was aware enough. He says, bring me a letter from Google. Then they go to some small Google somewhere where their friend works, and they get a letter and bring that letter. Then when real Google shows his face, then they say, if you don't solve this, I take you to court. I take not only the speculator, but you, the CC, to court. Okay. So then we show the documents, and then the real owner says that I am the owner, I can prove I'm the owner, and I think this letter is not authoritative. Okay? Then we become saved. In essence, what I'm saying to CC, collect a lot of information because you don't know where the issue is going to come from. As a result of these things, our CC made a policy to go very extreme, and that affects numbers. So I'm saying there's a trade-off between opening up and also avoiding disputes, okay? In our case, if you want to put something in .com, they require that you show your company registration certificate or some other kinds of mark for you to have that. If you're an individual, then you have to show, KYC type of things so that we can manage in case of disputes. Now, the net result, of course, is a much smaller TLD, and so we are thinking of how to relax that and open up some more. Okay, but meaning if you can do it, but you can use policy sometimes to do it, but it has consequences. Now, there is the issue of regulators now becoming keenly interested in running CCTLDs, and I'm sure in some countries this kind of transition is going. It may have to do with some misunderstanding that this business is a high volume, low price business. So from afar, the regulator thinks, oh, there must be a lot of names, and so there's a lot of revenue. And because of that, they have an interest, and they see the CCs, quote unquote, like property, as opposed to service to community. And that also creates some problems. And many a times, banks also are concerned about payments. If they have international payment regulations, they are concerned that you may not be following or whether you are following, because we always have to transfer money out, okay? And so you can become scrutinized by your, in our place we call them IOCO, which is economic crimes, et cetera, et cetera. So there are all kinds of, and you really need to have some legal help. Now, sometimes these intellectual property things can become nasty, but invariably we try to avoid them, and we try to mediate. We follow the WIPO UDRP, but it's not also being used. With respect to law enforcement, as soon as they come, as for me, I unilaterally take the name, make sure that the person accepts that he's doing the wrong thing, because I can't fight law enforcement. I've been to court too many times, and so I generally try to side with the law as much as I can to avoid the disruptions of the service. My service was at some point attempted to be shut down by government or related functionaries, but we rolled over the network to other places, and the service continued. But it's still operating, and I'm anxiously looking for a good host, which is supposed to be the National IT Agency, and once they seem to show the capacity of being able to continue the technical operation, that will be done.
Thank you, Prof. I think I'll now open up the stage for the participants. You have the panel here. It can't be better than this. There are two lawyers here. I hope they are not going to charge fee notes for any advice. We have Professor here. He's also agreed he's not going to charge for his time. Lucky, the millionaire domain CEO, is not going to charge for his time. So you have the guys here. Now, I think we'll use the formula we used in the morning. If you have a question, line up here, or, oh, there's another one there. Moses.
My name is Moses. When you open up other CCTLD or some extension on your CCTLD, I think there should be a sunrise period that you tell public to come and register their domain on that extension. So if I'm a smart guy and register some domain, I waited for the sunrise period, so Google maybe they didn't register their domain on that extension or on the new CCTLD, and I register Google.anything, and I'm expecting Google to come and negotiate and do business. Is there anything bad or wrong with it?
You're talking of cyber squatting?
It's business. I don't.
Business,
Is it cyber squatting?
Okay, you're talking of being a domainer?
I'm going to pay for it. I pay for, people register domain on the GTLD and they make money. So is there anything bad in doing it on the CCTLD?
I just wanted to clarify your question. So you're talking of a domainer who registers something like Google and so on, isn't it?
Sorry, Professor, you get my point here.
Okay, fine. Question, we'll take 3, then they'll answer, then the next 3.
Thank you very much. I was wondering if...
they don't know you. Introduce yourself.
My name is bob.co.ke. No, it's not. Okay. Chair, I need your protection. I wanted to find out from the learned friends in front, not from your educated counterparts, how would you advise registrars and registries to avoid lawyers? Or would you advise registrars and registries to avoid lawyers? Is it a better option? And then what do they need to do for that to happen?
Thank you. The third one?
Paulos Nyirenda from Malawi, just in case. So I want to ask the reverse question of the first one. I have been delegated a CCTLD, right? Or I've taken over a new CCTLD, and I see a lot of names that I could easily convert to be high-value names. What do I do legally to either withdraw those names from the current registrants and maybe go into a Sunrise or up the value of those names? Is there anything I can do to change the status of my new names that I have taken over from the previous manager of the CCTLD?
Thank you. I think let them answer the 3, then we can proceed to the next batch. One was specifically directed to Professor Ni.
Yeah. Okay, in my case, I'm talking of a legacy CC. So I don't have the options of Sunrise. In fact, this existed before the UDRP and all these things came. And the person perhaps took the name around just when UDRP had come, around 2000, 2001. So all that we had was protecting yourself legally. Because we could see visibly that the name is a mark that we know. So all we could do was to ask for as much information to protect ourselves as possible, which was, you say you are doing it for Google, then please bring me a letter. And when you bring me the letter, I don't make you the owner. I make you the one who pays the bills. The owner is Google, because the letter you brought was on Google letterhead. So notice how I'm, tiptoeing the legal terrain there. I'm saying, you say you want to register this. I can see it as a mark. If I didn't know it, then it's a different, but I can see it. So then I said, bring me evidence. You bring me the evidence. I keep it on file, okay? And if any issue comes, then that's what I'll take to court. By in so doing, at least I'm able to manage it, and that was the example.
Okay, just hold on, Moses. I want Lucky to add on it. You know, he's just finished the sunrise. Yeah, just hold on.
I just want to add to the question.
No, hold on first. Please, put off the mic. Put off the mic. Thank you. You can stand there, but let Lucky.
Thank you, Chair. Actually, you know, for me, once we go into dispute resolution, it means something is broken. The horse is already bolted. We need to be proactive. As you said, Sunrise is going to be, or is one of those mechanisms to ensure that trademark holders are protected. And nothing should stop people to apply for a name once it's outside the Sunrise phase. The process of first come, first served kicks in. But people need to be aware that you can also protect your names by registering them. This is a defensive stance that one would take. What you think is your name and it's valuable, you can reserve it and set it aside. Even if you don't use it at that point, but you have a plan to use it down the line, nothing stops you from doing that. This is to defend yourself against the Moses who are looking for that name, that premium name, and they will want to on-sell it, you know, to other entities who are interested in that same name. So those are two things, you know. ADR, it's broken. And we need to understand that once it's outside Sunrise, it's first come, first served. But to avoid that, you then need to institute the defensive mechanism where you register those names ahead, even if you're not going to use them. That is one of the mechanisms that can be used.
Thank you. As the patient's paid, we are happy. Thank you. Yeah, to the lawyers, how do we avoid lawyers?
We're unavoidable. Well, I think that's a great question, and it speaks to what Lucky has been trying to underpin, is the preventative aspect of things. Prevention is better than the cure, than going through the entire dispute resolution process. So initially, I would say that let's not try and avoid lawyers. I think it's to enable the African lawyer to be able to advise CCs and the domain space in general accordingly. Once they advise them in a more I guess aligned way, then we'll avoid the litigations that are going on. Because the lawyers are the ones who would advise you, okay, we need to take the litigation route. Well, there's an alternative dispute resolution that is in the contract that you sign when you're registering your domain. So the lawyers don't understand that. If they don't understand that, they take you to the litigation route. The litigation, as we all know in our African courts, takes numerous years. That's a lot of money. And once that judgment comes out, the value of that domain is no longer as valuable as you would wish it to be, right? So my plea would be we should have that engagement with the lawyers, and that engagement will actually, as I said before, will make this particular space more vibrant in the sense that things will be happening in line with the rules, in line with the policies that we have, in line with the international standards that we've set for each other. And I think that's my comment on that. So the legal advisory aspect of things is very important. Let's not try run away from them. I think maybe Sarah might have something to add.
Yes, Sarah?
Naturally, I do. I'm a lawyer. The traditional conception and perception of a lawyer is the problem. Was that barak.co.ke? Yeah. Oh, it was Bob. The perception is a lawyer will save you to your last cent. But legal career is, well, for Africa, it's expanding slowly, but I'm sure .ZA are doing well on that aspect. The traditional lawyer would vie for litigation, but with the trending world and with the emerging fields all over the world, particularly in Africa, even in oil and gas, not just technology, the role of a lawyer, it's not only the role of the lawyer, but also the African culture and the business conducive way has been not to have the winner who takes it all, which is the outcome of a traditional lawyer role of litigation. We want to stay business partners. We want to continue having engagement. And so there is a whole extension of a legal career in alternative dispute resolution, which is what we are doing here. There are lawyers who are trained to mediate. You will not hear a word of court action. They are trained to make sure that people come in a room and talk about things and things get sorted. And then, of course, there's arbitration and all these other sort of things that we are talking about. But lawyers are also trained to, they're rather defensive. They are looking out for the fallout so that they don't want the fallout to come out, so they have this defensive mechanism. So even for the registrar who will come up to me, I'll tell them, yeah, you guys are registering domains and you're not putting the right domain name holder, the right contacts, for instance, on the WHOIS. This will get you in trouble because some people will come up claiming, starting a domain name dispute, and you'll be in trouble. You are not the partisan here. Put the right contact so that when there's an issue, you are not caught amidst this dispute. And just to respond to Moses, I think, as I was listening, my legal mind was telling me, so how is it like when somebody owes me money and they're not paying me, so I decided to visit them at an odd hour and I come with 2 friends in dark clothes and a big gun, you know, because that's how we do it in business. And as a lawyer, and as his lawyer, I'll tell him, you know what, that's how you do it in business, but this could potentially cause you a legal action of, you know, assault or intimidation or something like that. And you can only know this if you speak to a lawyer, and I'll tell you why. Because with the CCTLDs that have opted the Uniform Domain Name Dispute Resolution Policy, everyone who registers a domain name under a CCTLD that has adopted that, they have consented to being bound by this policy. And under this policy, you should not register a domain in bad faith. You should not register it if it's not legitimately yours. And you should not register it if it has a confusing, similar, or it resembles someone else's trademark, period.
Thank you. Paulos, I think your question was answered. How do you? Just get, because of the interpreters.
The question was, I have been delegated a CCTLD and it has some really good, valuable names. Is there a way I can legally upgrade the value of those domains? So, normally you would do it in a sunrise, right? But in this case, they were registered by a previous delegated CC manager. Is there a way, or there's no way? I just wanted to get an opinion from the lawyers.
Okay. Oh, okay, fine. Anyone can answer?
I would respond with a question, because when you are delegated a CCTLD, you have registrants. So I would ask you, who are the owners of these names? Because they own these names, they registered them at your CCTLD. They don't belong to you as the manager and technical contacts of the names. So I'm not sure you're responsible for upgrading them.
Let me try this. Dr. Nyirenda is asking how to improve the value of the name, which I think is a factor of the market, how the market perceives that name. And the value of that market will be perceived by the demand in that market. If an entity would, as an example, procure a name and then create value by building a website, a web page, which becomes very attractive. It has a lot of traffic that comes to visit that website. Then he eventually makes it available. He sells it to the public. That would be one way of creating value. Creating value is actually, an external factor. It's a market-driven, factor, in my view, if I were to respond to your question, Doc. Yeah.
Okay, thank you, Lucky. I think Ali was there first, then Mark, then you. Then we'll take the next three. Sorry.
So I have several questions. First, to my lady friend, my lady lawyer friend, there's a privacy issue that is now seriously being discussed in the DNS circles regarding who is. I would like a comment on that. Some school of thought say I don't necessarily need to put my full addresses when I register a domain. In fact, players like GoDaddy today charge you extra. I don't know, at $7 or something. Where's Kariba? That's a business model right there. $7 a year or something to not display your name and your addresses and all that. What is your comment on that? To my good friend Lucky and possibly Abdallah, what is your comment or your reaction to the issue of so-called brand names? So I showed Abdallah a few days ago, there's some enterprising Kenyan who has registered alibaba.co.ke and alipay.co.ke. The question is Alibaba a brand name? Who started Alibaba? I mean, I grew up reading Alibaba as a story. So where does Jack Ma come in saying he owns the brand name? Those are the conversations that we must have. The other one is the issue of certain generic names. So, for example, vodka.africa. Somebody can say they own the brand, the name vodka. It's vodka is not a brand. It's actually a type of a drink. Those kind of things. How do we deal with those issues, and how do we deal with them judiciously, fairly, and legally? Those are three tough issues to actually get them right. I think we had a very interesting case in Kenya. Was it last year, Abdallah? Kenya, uhuru.co.ke.
Yes, uhuru.co.ke.
So, for those of you who don't understand Kiswahili, uhuru means freedom. It's freedom, but it's also the name of our president. How do you deal with that? Thank you.
Mark, then William.
I was going to come and try and come to Paulos's aid. There's two types of domains, the domains that have been registered and the domains that have not yet been registered. The not yet been registered domains that might have higher value, other people call them premium domains, and it's common practice for registries to potentially mark up a list of what they would call premium names, which are often generic names like colors or like vodka, etc. And that's how I would come back on that. So that in order to get a generic name, you pay more than you would a standard name. I would see that as common practice. The other case is where a domain has already been registered and is in use. How do you up the value of that? Well, there's 4 countries in Africa which use Freenom for domain registration, and their numbers are very, very high. But the contract there is the domain has been used by people but has not been paid for by people. So the domain is still technically owned by the registry rather than the registrant, in which case the registry does, and in their particular case they do act to their best profit. For example, taking the domain away from a registrant who is using that domain name very, very successfully. Something I don't like at all. So I presume if you have a list of generic names which are not actually registered, you can probably do as you wish, I would have thought.
Thank you, Mark, for coming to the rescue of the panel. William?
Thank you. William Stuckey. I'd like to also speak on the same subject. Paulos, I would advise you that in terms of premium domain names, what are and what are not premium domain names, you should be guided by your community and their wishes. In terms of trying to charge more for domains that are already registered, you will find yourself in a world of pain if you try that. Don't do it.
Thank you. That was also a comment to assist the panel. Okay. I have 2 questions. Is there a third one, or we answer the 2? Oh, there's a third one. The third one, please.
My name is Yawi from the community. I have a question. Yeah. So we are at the Danish Forum. So there is something happening. I don't know if you are discussing about it, because we are talking about best practices, and the Prof also mentioned that when you come to him to register, he asks for some documents. But I don't know if you are touching this issue of some service providers in countries, related service like web hosting. There's people who register domain names, because from the community I just want a domain name. I go to these people and they register, and the lawyer said they register everything under the name. So I don't know if during this discussion or at a country level there is something happening for us to educate, and then also if something happens, how to help the owner, not the registrant, the owner of the domain name. I'm talking about the generic name, for example. So it is difficult sometimes to solve issues. I don't know if I'm clear. Like I'm a company in the country. I use a provider to register my company that for example, a generic name. Any generic name, but there are issues. It's difficult sometimes for the end users, because they are not educated, to solve the problem, and also the provider are abusing the community, the user. They are abusing the end users. So my point is, what can we do to educate and to raise awareness so that people know more about the registrant, the owner of the domain name? So it's just an issue I want to raise, how we can maybe share practice and maybe take action, even at the country level, to protect the users. Because when it happened, I think the provider did just take advantage of the community members. They don't know, so they take advantage. And that is an issue I'm just mentioning. We can see how to or share practices about that? Thank you.
Are you saying the who is information is for the registrar instead of the registrar?
Let me give a concrete example. An end user come to me for a website. I register his name abc.com, and then at the end of the first year contract, I will tell him, you pay me now 10,000 a year for the services. If I say no, you put any other content, use my domain name for what you want to do. Something happening, but we are not discussing this to share practices. So this is what I want to raise.
All right. So we'll start with the first question. Privacy issue and the who is display. I don't know who will. Sarah is ready to tackle it.
Yes, Ali. I recognize that you can actually pay to hide your information on the whois. I believe tzNIC registry has a similar service, but if you are driving at that with the intention of having your information hidden, when it comes to a dispute, it wouldn't apply. I'm sorry. Because when a dispute is declared, then these, the selected panel has some powers under the policy of dispute resolution to ask to lock the domain, to get the right contact information of the domain holders, the registrant. And so at that point, you'll be revealed.
Chair, can I just make a rejoinder on that? I don't mean a dispute. Privacy can mean somebody may want privacy for various reasons. I want privacy for, I just don't want my name. It's not that, there's no dispute. If a dispute happens, it happens. Obviously, there are certain parameters that one has to go through, one. Two, you may be a dissident. You may be somebody who is fighting for certain rights. You may be a human rights campaigner. You don't want your name appearing in that who is because you know that your government will, whichever government it is, will clamp down on you. How do you deal with those issues? I think it's not, what I'm trying to say is that it's not a black and white thing, and we have to deal with certain things judiciously. It may be that it's like the Pirate Bay issue with, what's that country, Abdallah? Pirate Bay, not Sweden. There was some intimidation a month ago. It was on the DNS, the CCTLD.
The one who appealed to the CCNSO.
CCNSO list.
Costa Rica.
Costa Rica. So in that particular case, obviously, you have certain due process that one has to follow. We know, those are things. But, there are different shades. As a community in Africa, we need to start understanding and dealing with such issues in a manner that is fair.
Okay, when the host wants to speak, let.
I'm just a delegate. I just wanted to add. I'm Abibu from tzNIC. What Sarah was clarifying that for the case of tzNIC, it's just the awareness of the registrants, but you are allowed to hide some information under the who is. But I just came to learn that also that service is chargeable, but at the moment we don't charge, and even the registrants are not aware. So we have such a service, but the registrants are not aware of that service. So there are some parameters which we can hide in our policy, but in case there is a dispute, then that information is revealed for administering the dispute. That was what was communicated.
Thanks. Just one last thing. Sorry, Chair. I think it will be important as a community to articulate this. So when I was saying this, I wasn't specifically pointing out to .tz. That's the reason why I gave the .co.ke example. But there are certain good cases, there are certain best practices that we can pick out from, not just across the continent, but globally. Thanks.
I think Professor wants to put in a few words.
I think this issue is more a registrar-focused problem. In the 3R model, it's a registrar-focused problem. And yes, they do offer for you to conceal it, except for the cases mentioned, like dispute, and also law enforcement. Meaning, if there's a legitimate request from law enforcement, invariably you need to provide them an interface for them to have access to that. And this is where the conflict may come, because law enforcement may not be the same law enforcement everywhere. So, but still, you can also not deny law enforcement because it may be to save our lives. So that one is a larger issue that we need to somehow bring law enforcement here, just as we tried to bring lawyers. Was it? Where did we go? It may have been Zimbabwe. There was some activity, meaning, this is the statement we are making about expanding our community to include those we normally will not interact with. And if law enforcement was here, they might tell us something about the criteria to expose and not to expose. And we do legitimately have to satisfy their needs, but at the same time, we have to work towards protecting the rights of people. That's one. The issue that Yavi was trying to poke at is a dangerous problem, because somebody has turned himself into a registrar or reseller, but he is now extorting. He is not practicing what our RAA may call for. In essence, he sells the thing to you cheaply, and then when you become hooked to it and your site has value, then he says, if you don't pay me for everything you owe me plus 10 times more, then I'll take your site. And I've seen many cases like that. And we don't really have much powers beyond education. In our case, when such a person comes at the registrar level, walks into the office, then we make sure that he gets that person to go online and register the domain. Then he can come and do the rest of the web technically related things. Meaning we try to separate the name from the service that he's going to provide. Okay, we tell him that if this is not for you, that's in the generic area. If it's in the CC area, we have more powers, because our local policy will require that you present some documentation. But in the general case where you are registering the generic, it's much more tricky. But it's education. You have to educate the registrants to make sure they themselves do the registration of the names, and then hire a technical person to help them do the rest.
Thank you, Prof. Now, a comment on issue of brand names. There was a question about brand names. I think you had him talking of, there was a domain in Kenya. Someone registered a domain called isuhuruinkenya.co.ke. Those ones who don't know, Uhuru is the president of the Republic of Kenya. So what he used to do when the president flies out, he puts on the website, no. When he flies in, he puts yes. When he flies out, he puts no. Yes, and it was a big dispute. And another one took uhuru.co.ke. Yeah, I think that's what Ali will not do dispute resolution here on that. Now, he talked about also Alibaba. I'm just putting the question into context so that the team can answer. Jack Ma was in Nairobi last week. The owner of Alibaba, the online business, was there. Was it Friday? Yeah, as he was giving his lecture, all his domains went up. Somebody bought all his domains. I mean, not his domains, but domains with his name, and Ali alerted me, he's always online. We are still waiting for that dispute, if there's any. So, for the panel, if someone registers vodka.africa, I think Lucky also gave us a scenario of River-Nile.Africa. Is it Uganda to own it? Is it Sudan? Is it Cairo? All of those guys have River-Nile, so we will own it. Just to share with you a perspective before the team answers. Those ones who have been in Kenya, they know there's the tea called Ketepa. Those ones who have been in Kenya. Ketepa is a long-term brand for tea. When Ketepa wanted to do trade with Saudi Arabia takes a lot of tea. They found someone had already trademarked Ketepa in Saudi Arabia, so they usually have to deal through that person, despite it being a brand in Kenya. So I was just bringing in another whole new perspective. So I hope the team understood the question on brand. I can see the lawyer on the left of my side dying to answer.
Thank you, Abdul. Thank you so much. The question of that has been pointed out and highlighted there, it's quite pressing because there's such an array of disputes that happens. The brand names, the geographical, cultural, the generic names that he has mentioned. And yes, there has to be some sort of, if I can call, directive of some on how to deal with them. Because even if you read the precedents that is maybe from the US, arbitrators are very, tend to be, from the cases that I've gone through, arbitrators are cautioning against or against the practice of too readily being accepting these complaints, and so there is no consistency in the aspect of the precedent set with respect to names, for example, brand names, and so it's something that really does need to be tackled in the African perspective, and I would maybe suggest, if at all, something that we could explore as the, or maybe the African DNS Forum could explore, is having an African sort of, an African dispute resolution issues discussion forum of some sort that would capture the privacy issues that he's highlighted. We could explore from an African perspective how we could tackle them. And that could also maybe amount to having an African UDRP policy in place. Of course, maybe the policy would reflect what is there in the UDRP, but more catering to the issues that we're facing in the African space, especially the registrars, the registries, and the players in that particular space. And I think that's what I wanted to say. That sort of organization coming together, engagement with the lawyers, especially on the privacy issues, because they're very, very important. It's a human right-based sort of principle. And so if it's human right related, the dynamics are quite huge. So it's something to think about.
Thank you. Maybe Lucky, you want to?
Thank you, Chair. Alibaba.co.ke. Definitely no. Nothing stops whoever registered that name in Kenya to do that, but it does seem like it's done in bad faith. It does have a resemblance to the Alibaba. If Alibaba is not a trademark, then it's a different case. But if it's a trademark, equally, that's another issue for ADR. But as I had said earlier on, there is one other important lesson that we need to take away, is if you think there is a premium name that is important to you or your trademark name, make sure that you reserve that name in all the countries where you believe you'll be conducting trade, and in that way you are covered. Otherwise, you are exposing yourself, or you will have to go and defend your name through the ADR process, which would be very costly. It is cheaper to acquire the name, ring fence it, and have it for yourself. If there is Alibaba, if Alibaba has not reserved his name in South Africa today, somebody will register alibaba.co.za or alibaba.africa. But the best thing for Jack Ma is to try globally and buy names as far as he can. And that's the way to do it.
Thank you, Lucky. I'm sure people have already registered alibaba.co.za by this time. Sarah?
I couldn't have said it better. You've spoken like a real lawyer there. That is why I love the policy with the three, can I call them? Yes, the three, can I call them ingredients for determining the rightful owner of a name. And usually when you go when you go for a session of a domain name dispute, it's a telltale. You know how he's put it so well. If it's a trademark, there's no question about it, because this person will bring with a complaint a certificate of registration of the trademark. Now, there are other issues that might come up that someone might bring out, like, yeah, but it's a trademark registered in US, not in Tanzania. But then there are laid down procedures of how to tackle that. If that might fail, the timing of the registration of this alibaba.co.ke is also a telltale. I mean, there'll be, if a domain name really is, it's an entitlement of this person who is willing to go for a dispute. Usually, if it's an innocent part, there's no bad faith involved. It usually ends in their favor in a major way, and it's you can see the bullying, coming out so outrightly. It's not really rocket science. You can sit right there and read those proceedings and tell that, oh, I think this is an agenda to it. I think this is, I'm trying to say this process of having of dispute resolution has a lot of logic and common sense tied to it, but with the legal sense backing it up, particularly with the evidence bits and the registration bits. And that is why bob.co.ke, you should not be avoiding lawyers, because at this instant, they will instantly advise you or advise Alibaba to register all over the world for the protection. I just wanted to...
Thank you. I think we are going now to take the next 3 rounds. Do we still have time? Barak, is Barak around here? We still have time. Okay, fine. William.
2 points. Firstly, as we will be telling you tomorrow, in terms of intellectual property, we do not suggest that any kind of pre-filtering on the basis of trademarks or anything else should be done with respect to domain names. The statistics from South Africa, for example, with over a million COZA domain names, there have been fewer than 700 disputes between 2007 and now. So it's way, way cheaper to solve the problem afterwards than to try and solve it before the time. Second, related to that, an ADR process is not an expensive process. The cost of doing an ADR, having an alternative dispute resolution, is just a domain name dispute resolved through ADR in South Africa is less than $800, way much cheaper than the courts. The other point is that I would like to correct, I'm not a lawyer, but I would like to correct my learned lawyer friend. The fact that a word is trademarked does not make it simple. that a trademark can be in there, and the laws of various countries vary. But if the fact that a word or a phrase is trademarked in one country does not automatically make it trademarked anywhere else in the world. Point number one. Point number two, the fact that a word is trademarked in a particular category does not make it trademarked in any other category in that same country. So, for example, in South Africa, there are 43 categories under which names can be trademarked. So you can register Alibaba as a trademarked name of a restaurant. You can also register Alibaba as a trademarked name of a hardware store. And you can also register as the trademark name of a magazine. And those are all non-overlapping categories. So if I was to register Alibaba.co.za and one of those trademark holders, which of those trademark holders would in fact have the best claim to that name? It's not a simple issue, even when it is trademarked. Thanks.
Thank you, William. Joe Lagna. Did I remember your name well? Good. It's Joe? Lasagna. Okay.
Okay. So again, it's Alanya, like lasagna. Okay, so as I figured it would happen, William actually did express very well what I was thinking, so I won't go over that again. But as having some experience working for 101 Domain, I'm not with them anymore, but 101 Domain is a registrar in the United States that for 4 years I worked for them, and we focused on brands and helping brands to register domain names around the world. And so we did find, as he explained so clearly, that it is not that simple, and sometimes, you know, brands overreach too. So all I'll add to it is that I think it's really helpful and valuable for registrars and registries to try to remain neutral and to allow the dispute resolution processes to work as they were designed to work. And yeah, to look at some of the precedents that were set by the Forum in the United States and WIPO in Europe. There's a lot of existing decisions that were made in arbitration that are valuable, you know, and helpful to the people that make those decisions. So I would just say that being neutral is probably a good idea. And another reason I say that is because, in fact, there's a pretty strong, there's a lot of evidence of reverse domain name hijacking, where actually brand names overreach and try to take very generic terms that they really shouldn't be entitled to. So that's another reason that it's helpful to be neutral from our perspective. And then, since I'm not going to spend time on what William was talking about, I did want to say one thing about attorneys, and I'm not an attorney, but I really respect and value attorneys, because attorneys help you to stay out of the kind of trouble that we're all talking about. So if you use an attorney in the beginning, you might be able to avoid spending a lot of money later on. Just that comment. Thank you.
Thank you. I think, oh, okay. You may have to say your name. I think I don't know your name. Quite a number of guys, but I think I'm...
No problem. Mark Tinker, CCOM. I think just as a practical experience from our side is we have, I think on a weekly basis, receive anywhere from 40 to 50 requests to register ccom.ch or ccom.pk or ccom.my or ccom.us from all manner of registrar and all manner of business that brokers registration services around the world to say, look, somebody has submitted a claim against your company, here's the chance for you to register now, and so you don't end up in trouble and so forth. And I think in 2011 we took it a little seriously, but with the frequency these things started coming out, we just decided to ignore them. For us, it's not important to have a ccom.se, for example, or a ccom.ca, or a ccom.br. The ccom.africa is something we've taken up, which I think is more than sufficient for us. If someone decides to register ccom.pl in the future, that's fine. We don't think it affects our business. We don't think it impacts the kind of clientele that we are dealing with. And we're not about to go rushing around the whole world, registering CCOM in every country and maintaining that on an annual basis.
Thank you for sharing your business strategy.
Okay. Just a comment.
Okay.
On the same, sitting in the SE or the commercial section of the GNSO, the comment is that these days big companies like CCOM or BT, they're telling the registrars that if you register my name without authorization, I will take you to my lawyer.
So get a good lawyer. So you can't avoid the lawyers. Any one burning question? I'll not take two. Only one burning question because of time. Yeah? Or comment?
A comment.
Okay. Oh, you're there, Ali.
A comment.
I saw you going out.
I flew in. Actually, this is just free advice for brand owners. There's something called defensive registration. There is no way you can stand here, with all due respect to my brother who left the stand here, there's no way you can stand here and say, my domain does not matter when somebody registers it, especially when you're aspiring to become a transnational, a global company. Trust me on this one. Yeah, this is free advice. Somebody can just be malicious, register your domain, and do a blog on that domain. By the time, negative blogs, by the time you've gone back and forth to take that website down, you're in trouble. So you need to just think the trajectory of your company. Are you going to be beyond one country? If you're aspiring to do that, please just register your domains. That's just free advice. You'll thank me for it.
Thank you. I think we can take it serious for someone who once sold a domain for $7,000, one domain. Yes, Abib.
Yeah, Ali provided a very good advice, but its implementation is quite difficult. And what basically CCOM shared, or Mark shared, is a real fact. And as a register operator in the past, we received a lot of requests that you should protect this domain in China. Maybe TCRA for the regulator, you should protect it in China. But from my understanding, based on the policy, there are two issues: registering a domain in bad faith or using the domain in bad faith. So if you can't protect it across the globe, then there is another chance of defending your domain based on the bad faith use of it. All right? Because you can't protect it everywhere. The abbreviation have different meanings. It could be TCRA here, meaning Tanzania Communication Regulatory Authority. TCRA in China, meaning something else. But now, what you need to follow up, what that TCRA in China is using on the website, what information is being presented. Is it defamatory to what you are doing in your country? Then you can raise a dispute.
Thank you. We need to be brief. I'm sure the interpreters are tired now. And yes, they are tired by now. So let's give a few minutes. So your comment should be very brief so that the panel, for the sake of the interpreters. Thank you.
Good evening. I'm Mohamed Said from a government agency. We are a registrar. We used to register government website, government domain, .go.tz, .ac.tz. What I want to address here, there is something going on. I'm not sure if you are aware. There is so-called online business marketing. What they do, is to invite investors. They put their money. For example, I'm the first. Then I invite my friend, and my friend invite his friend. So the network goes like that. And every friend you invite, there is some bonus you get and profit. Right now, speaking from my experience, there is so-called AmazonTrader.co.uk, there is d9club.com, there is btc.io, and I'm one of the victims. So you put your money, so you start earning the profit, you can withdraw. The first who registered, they become able to withdraw, but eventually that website or company collapses. So people lose their money, and there is no way you can go to address the issue. So what I want to ask you, during registration, there is some where you check, there is a checkbox you check, terms and conditions, that you have to agree that according to their terms and conditions. And what I know, each domain, there is public IP mapped to that domain. And each public IP belongs to a certain ISP. And that ISP has a database of all his public IP that used to allocate to the customers. So when that domain is registered, we can know the company that used to register that domain. We can know the ISP who is responsible to allocate that IP. So where are those people until this problem comes up? That's what I want to know. I think I made myself clear.
Thank you. I think, first of all, I'll say sorry for the money you lost. And we have taken the advice from him. I think I want to close. I hope you'll not take more than 30 seconds. Please. Oh, okay, please.
I am a reseller, and it is hypothetical. I am a reseller and I'm selling domains. And it happens that I sell the domain to somebody who is a terrorist, and I don't know. So my question is, if that comes back to me, how am I supposed to protect myself? And this goes to the 1,000 lawyers chain at the bottom of the sea, which is a good start. Thank you.
Thank you. I'll not take any further comment or question. I'll ask the panel to very briefly, between the two lawyers, who will answer that one? Magdalene, you'll take it. Okay.
The last question?
The last question, just the last question. It says a domain is a reseller, the domain, you got it. Okay.
Thank you. So, as a reseller, you would have sold the domain in good faith, I'm sure, and the person who then conducts malpractice within that space or the domain, I guess, would be liable for whatever is undertaken on that domain. So you'd have some sort of fallback, I'm sure, on your assignment of the domain to the new domain owner, and I think that's where the blanket that you'd rely on the terms and conditions of that sale. So there'd be some sort of a liability or exclusion of liability clause that you could rely on once you do that. So, and that's why we say go to the lawyers.
Thank you very much. I will have continued, but time is up. I'm a stickler to time discipline. Now, first of all, I would like to thank participants, because if the panel doesn't have participants to talk to, we'll talk to ourselves. Participants like Yaovi, and I can stuff like Bob. And if you're just walking in at the hotel and came here, also will thank you. Secondly, the panel, Professor Ni, for ensuring that he speaks simple English for simple minds like us. I think he tried. The lawyers, I usually fear, they usually say here, in, here, after, here, under. I think they avoided that. Thank you very much. Lucky, a businessman, he didn't refer to any stock exchange and so on. Thank you very much for that. A round of applause for the panel, please. Now I'll hand over to the organizers to pick up either Bob or Barak or Abibu. Okay, Bob. Are we released?
Thank you very much. I think the moderator forgot himself, so a round of applause to him as well. Abibu doesn't want to stay in Serena, so come back for your key if you miss it. But I want to say that the lawyers still managed to use precedents somewhere. And we also got to learn that maybe we don't need to avoid the lawyers, but avoid litigation. So we are stuck with the lawyers. Thank you very much, everybody, for having been very engaging audience across the day. It's past, or in Swahili, it will be something kasorobo. But it's beyond 5:30, and we are still very active, and all our eyes are still open. Nobody is resting his eyes yet.
People can do the communications, and we can go back for the cocktail at 6.
Yeah. So if you're not resting your eyes, it means you are still very wide awake. So thank you very much, everybody, for staying with us this far. We promise tomorrow we'll finish a bit earlier. So we have a cocktail planned for 6 o'clock, and I think we can use between now and 6 o'clock to maybe say hi to your neighbor that you're now seeing for the first time. And if you want to drop a bag around, you can do
Exhibition,
that.
is it there?
And the venue for the cocktail is somewhere around the pool in the open space. And I invite everybody, but please remember your badge. That is your only domain, so that at least we know that you are from this forum. So, otherwise, thank you very much.
One thing, Bob,
yeah.
Please. We always forget to clap for the interpreters. You know, we take it for granted. We just put on things.
They have not finished. They finish on Friday.
No.
But anyway,
clap
our
for them,
interpreters, I think they've done a great job. Okay, great. So tomorrow we start at 9 o'clock. It is 9 o'clock. It is not any other 9 o'clock. It is 9 o'clock. Saa 3 asubuhi kamili. Asanteni.